Good morning. Welcome to another oral argument session of the 5th District Court of Appeal. As our marshal has indicated, I'm Judge Lambert, presiding over our 4 cases that we have today. If anybody's here, just so World Trade Towers and Space Coast, that was dismissed yesterday by the appellant, so if for some reason you're here on that case still, there's no oral argument in that case. That case has been dismissed. Let me introduce the panel that's going to be hearing cases today. To my right and to your left is Judge Jay Cohen. And to my left, your right, is Judge Robin Lemonidis. She is a circuit judge from Brevard County, sitting in this week for Judge Torpy. She's been helping us. We've been very appreciative of her efforts here. And so she is with us as the third member of our panel. As I indicated, we have 4 cases today. 1 criminal, 3 civil cases, 15 minutes on the criminal case and per side, and 20 minutes per side on the civil cases. If you happen to have a cell phone or other electronic device, please turn that off or put it in silent so you're not distracting the attorneys when they are giving their oral arguments. I will reserve 5 minutes on the for rebuttal for each side, unless you tell me something different. On the first case, because we have a cross appeal as well, if the appellee wants to reserve 5 minutes to also to address any issues in the cross appeal, let me know. If you don't, let me know as well. All right. That being said, I'll call the first case. 15-1524, State of Florida versus Anthony Marquise Jackson.
May it please the court, I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. This is an appeal by the state from a trial court's order granting post-conviction relief and ordering a new trial. This was the sole issue that was raised on direct appeal, and as Judge Cohen may remember, as he said on that panel, and while it was the sole and exact same issue that was raised on direct appeal, the state acknowledges that it's not law of the case because this court's decision in that case was a PCA. However, the state makes the same argument today that it made 6 or so years ago, and that is that not only was trial counsel not ineffective for raising 2 absolute defenses, but was brilliant by taking 2 defenses and giving the jury 2 reasons to find that the defendant's horrendous actions that night were either excusable or justifiable.
May I ask, do you believe that the amended petition, that the amended petition filed by counsel after Mr. Jackson already filed his timely petition, do you see that as an enlargement of a claim that Mr. Jackson made initially?
Of the ineffective assistance claim?
Yes, and the ineffective assistance. The one where he discussed, I'm sorry, the exact letter is escaping me, but where he talks about mens rea. He lacked the requisite mens rea to...
I think it was an enlargement. The state addressed it on the merits as if it were a valid enlargement of a previously raised issue. And I don't contest that at this point. I think that it's clear that regardless of whether that portion, I think it was letter J.
So you concede that it relates back? Because I don't think you did on your brief.
But the state argued on the brief what did not relate back was the claim regarding the stand your ground and self-defense that was a new issue raised. The defendant in his...
Or how about the insanity?
Well, it's clear that in the defendant's original motion...
His handwritten motion.
Right. He argued that trial counsel was ineffective for not presenting even more insanity evidence, his Social Security documents itself.
So you think a claim that it was ineffective assistance to raise insanity relates back to that? Is that what you...
No, absolutely not.
So that sounds like that's exactly what you just said.
Well, no, I don't agree with that. I don't think that...
You don't agree with what you said, or you didn't say it?
I'm sorry. I thought this was referring to the state's argument that one of the issues that was raised was not timely because it was raised subsequently, and that was the stand your ground. So the,
Therefore, the insanity, in your view, relates back? The claim of ineffective assistance for raising insanity as a defense relates back to the original?
no, it certainly doesn't relate back to the defendant's claim that counsel was ineffective for not presenting even more
It
insanity.
doesn't relate back, it's not timely, is it?
I would argue no, it's not timely.
But that's not the answer that you gave Judge Lemonidis.
And I apologize if I misinterpreted the issue that Judge Lemonidis was referring to. No, it certainly wouldn't relate back if it wasn't timely. I think the rule is very clear that if it's not a direct enlargement of the exact claim that was raised, it's a new claim, and it has to be, under the rule, it has to be timely, regardless of whether the court has ruled on the 3850 or not. I think the rule is very clear on that.
But surely you wouldn't hold Mr. Jackson, who was about maybe 24 years old, 25, 26 at the time that he wrote that ineffective assistance petition, you wouldn't hold him to the same pleading standard that you would hold a licensed attorney.
Well, I think the case law is clear that being a pro se does not allow any special privilege to a defendant, and therefore, in fact, I would say the vast majority of post-conviction motions are filed by pro ses.
Right. But what I'm saying is not that he's, maybe that's an inartful question. The question is if he puts enough of the facts in his claim that a lawyer would rephrase it the way that I'm not quite sure whether it was RCC or Mr. Joshi, whether RCC filed the petition and Mr. Joshi just argued it, or it was slightly different, but you wouldn't expect that Mr. Jackson would express it in the same terms that an attorney either from RCC or...
Well, obviously, well, no. And it's true. Of course, an attorney isn't, or the defendant isn't schooled in the art of legal terms, but that doesn't, and if there's a kernel of the issue in there, just expanding on the facts is one thing. In this particular case, again, the defendant was arguing ineffective assistance for not presenting even more insanity, and I think that's a perfect example of evidence that the defendant not only agreed with this strategy, but that he pursued it. He wanted this strategy.
Even more to the point, I think it's in the initial motion, the pro se motion, it was the ground E was the ineffective assistance of counsel. He lumped together a variety of reasons why he believed his trial counsel was ineffective. Number 3, E3, was you didn't bring in more records from SSI to show that I have this mental illness and I could not form the appropriate mens rea. Then in the amended motion filed by counsel after the 2-year time had run, it seems your better argument is that counsel then added more language to that specific claim and then separately filed claim J that said, and oh, by the way, you never should have raised this in the first place anyways. Isn't that fairly indicative that whatever language was added by counsel in E3 is the enlargement issue, and J is clearly a new issue which would be untimely and therefore should never have been addressed? Isn't that what you're trying to argue in your brief?
Exactly. I absolutely agree with that. And I think, again, the fact that the defendant himself raised his claim that there should have been even more insanity evidence clearly shows that the trial court's factual finding that he didn't agree with this claim or that he didn't agree with this defense just isn't supported by the record.
Okay, let's assume that we get past that. The misstatement of the burden of proof. How would you address the ineffective assistance of counsel vis-a-vis that?
I think that first of all, I think that was taken out of context. If you look at the evidentiary hearing testimony by trial counsel, trial counsel didn't have, for some reason, the public defender's office couldn't find the file. So counsel had nothing to refresh her recollection of this case. So her testimony was, yeah, she must have given a wrong statement of the law. If you look at the closing argument, and I urge you to read the closing argument again, the total closing argument, the state's double closing was only 8 pages. Defense's closing argument was only 15. If you look at it in context of the closing argument, it wasn't a misstatement. She was talking about this blended theory of the reason why his belief that he had to use deadly force was reasonable was because of his mental condition, that the state has to prove intent. That's what the argument was. It wasn't that the state has to prove he was sane, it was that the state has to prove his intent. So if you look at it in context, and trial counsel at the evidentiary hearing had nothing to go on, had none of her records, had not reviewed the entire transcript, had none of that. She clearly fell on her sword. I think she fell on her sword right after the defendant was convicted. There's no doubt.
Which is not uncommon.
No, it isn't. I guarantee I'll walk out of here today and think of a brilliant answer I could have given over and over again. We all assess our performance after the fact. We're lawyers, we want to win. In this particular case, her testimony in and of itself that I was ineffective, we all know doesn't carry the day on an ineffective assistance claim. It's considered in the totality of what was going on. The bottom line with regard to the trial court granting this motion for post-conviction relief is that the court's factual determinations aren't supported by the record, and the misapplication of the standards was just incorrect.
So on that note, though, timeliness notwithstanding, and we'll get to that, can you think of anything worse that trial counsel could have done? Anything more ineffective that trial counsel could have done?
You know, and clearly that question encompasses an assumption it was flat out just ineffective. And you know, this defendant got in a cab with a robbery kit, an armed gun, a loaded gun, a box of ammunition, mace, and latex gloves. Then he got in a cab, maced the driver, shot him, and robbed him. Those are the facts that this defense attorney had to counter.
Didn't they find money they found $124 in the cab driver's pocket?
I don't remember. I don't remember if there was money in the
Robbery didn't go well. But,
was it a well
successful or not?
Was it a well-executed robbery? Clearly no. He left his own driver's license in the cab. It was botched from the beginning. The fact remains, the state's evidence was he got in a cab with a robbery kit, then committed an armed robbery, but shooting the defendant, the victim, took his keys, his cell phone, and his wallet. The cell phone, the only means that the victim could have called for help. The keys to the cab, which probably were in the ignition, the only way he could have driven himself for help. Then the defendant fled, hid the evidence.
Right, so it's a tough case. We get
it's an absolutely tough case.
You're in your rebuttal time, just so you're aware.
Oh, and I will reserve that and just say, I think counsel not only was not ineffective, but was brilliant for finding 2 absolute defenses that either one or both together would have allowed this defendant to walk free. And I would point to, the state cited a case in its brief, but I miscited it as a second, Southern Second, it's a third second. I think it's Martin, with the exact same situation where a defendant wanted to use the insanity and self-defense together to show.
There's legions of law on that.
Right, so it wasn't ineffective. It was the best that this attorney could have done, and the defendant clearly insisted that she pursue this. He asked her about the insanity defense. When she said, you got to have a doctor, he grabbed that ball, ran with it, passed it to his mom, who went in for the goal. He wanted this defense from the beginning. He still argued it in his 3850. He believed it was a valid defense.
Thank you, Counsel. 252.
Good morning. May it please the court, Paula Kaufman on behalf of Anthony Jackson. I would like to reserve 2 minutes
Okay.
for our point on cross appeal.
Very well. Thank you. Go ahead.
With respect to the initial claim by the state that the court...
Let's start with the timeliness issue.
I'll be happy to. I would like to briefly summarize some of the record evidence as to what
We're
did
familiar with
happen.
it. Ms. Kaufman, you know that we're familiar with it. Let's start with what we would like to talk about, which is the relation back issue.
I'm sorry, the relation?
The timeliness, whether the post-conviction motion relates back, because there's no question it was outside the 2-year time frame, correct?
That's correct.
Okay, so therefore, in order for us to consider that, it must relate back to the earlier motion that had been filed by your client.
I don't agree with that.
Why is that wrong?
The argument in our brief is as follows. What happened was, on April 14th, 3 things happened, according to court minutes. There was a motion for leave to amend, which was granted.
Was there also a request for enlargement of time?
We don't know. There are court minutes, and the state is relying on the absence of any indication in those court minutes, but we don't know.
Was it filed within 2 years?
No, it was not.
Okay, so is your position the fact that you asked for it before the expiration of 2 years indefinitely extends the time frame for filing of the motion?
Well, it is one possibility that
So 10 years later.
that the court said when you file your
No,
response,
no.
your
We're not dealing with
motion.
possibilities. I'm dealing with what I've got in a record on appeal. My question to you is it your argument that if you've asked for it before the expiration of 2 years, that 10 years later you could file and it's timely?
If the court said when you file it, the state has 60 days to respond. Those court minutes reflect that the state did have a specific time period.
Are you aware of any authority that allows the court to expand the time period beyond the 2-year jurisdictional limit, absent an enlargement of a timely filed claim?
We would assert that no leave to amend was even required to be requested in this case. The original motion could have been amended.
Let's see if I understand that. You're not arguing then that it relates back to the earlier motion?
Well, that wasn't raised by either of the parties. This court has inquired of the state about that. To the extent that the court believes it may, I'll certainly go with that.
What if the court says it believes it doesn't relate back?
That's the court's decision. I would argue.
I'm asking you, do you believe that let's assume that that we don't accept the argument that you have an indefinite period of time to file the post-conviction motion, that you've got to do it, either get an enlargement of time from the court or you've got to file it within the 2 years, and that wasn't done. Are you conceding that the subsequent motion for post-conviction relief does not relate back to the original motion filed, the timely filed motion?
I'm not going to concede that. There were allegations.
Explain to me how it relates back.
There were, well, I believe Judge Lemonidis raised issues about that, and I'll simply rely on the questions that she asked. I've got limited time here, and I haven't even begun my argument, Judge. If I'll just
so I'm clear, I mean, I'm looking right at the rule regarding 3.850E amendments. New claims for relief contained in an amendment, and that's in essence what Judge Cohen is asking. If we think letter J, you shouldn't have raised insanity as a new claim, new claims for relief contained in an amendment need not be considered by the court, in essence the post-conviction court, unless the amendment is filed within the time frame specified in subdivision B, which is the 2 years.
And we've addressed that, Judge, in our brief. Again, we believe that the at any time provision applies for this reason. None of the eventualities had occurred that require the defendant to request leave to amend. The order had not, no order had issued disposing of the motion. No order had issued conclusively indicating that all of the claims were conclusively
Under that theory,
refuted.
the 2-year rule is illusory once you filed an initial motion for post-conviction relief.
Right, you could file on the day before the 2 years expired. I guess under your theory, you could then, because the judge doesn't react within 60 or 90 days or order anything, then he could file an amended motion that raises 25 different claims completely unrelated to the initial motion. And
Judge,
you'd say that's okay.
based on-
Is that what you're saying, though?
Yes,
Okay.
based on what
Can I go back to
happened,
my-
we don't know that the court didn't grant an enlargement of time.
But then I return to my question of, are you aware of any authority that would allow the trial court to extend the 2-year jurisdictional timeframe?
I would say the need not language. If this court is inclined to believe that the at any time language, because the 3 eventualities had not occurred in this case, the state hadn't even been ordered to respond to the original motion. If this court is inclined to rule that the at any time provision does not apply, then we believe the need not provision applies, which means the court need not consider any amendment that falls outside of the 2-year time limitation. We've argued in our brief, need not, the plain meaning of those words, and I'm going to presume that the Florida Supreme Court understands the plain meaning of those words. Need not is simply not synonymous with shall not or cannot. You know, if this had been objected to at any point in these proceedings by the state, and I'm not going to assume that the state was unfamiliar with the rules of procedure here. If this had been objected to at any point under Rule 3.050, even if the deadline had expired, the court still could have allowed this amendment. The court still could have allowed this amendment even after the time had expired upon a showing of excusable neglect.
All right, let's go ahead with your argument in terms of the ineffective assistance.
Basically, Anthony Jackson went to trial without a defense in this case.
Whose idea was it to present an insanity defense?
According to the record, it was not Anthony Jackson's, it was his family.
I don't know why you're saying that, because the record that I've seen indicates that it was his idea at the jail to pursue an insanity defense.
He asked about it, and according to defense counsel, the family insisted on doing that, found their...
You know, we're talking about an adult here, okay? You know, this isn't a juvenile, he's an adult, and you know, this mommy made me do it. I'm not sure where you're going with that. You know, he's the one that makes the decisions on the case ultimately, and he was the one that initiated the whole concept of going with an insanity defense. And then he gets his mother to pay for an expert, which
Judge,
they do, and then that expert is called to trial and renders an opinion that says that he was insane at the time of the commission of the offense.
an opinion that was not even based on the appropriate standard in Florida. That's no defense.
It came into evidence. You know, I mean, it maybe had the state objected that it didn't meet the proper legal standard, they might have been able to stop it, but it came into evidence. His testimony was that your client was insane at the time of the commission of the offense.
Initially, in his report, which doesn't even mention insanity, and initially in his testimony, it was a temporal break. On cross-examination by a skilled prosecutor, he said he suspected that Anthony Jackson had been insane for a long time. Judge, I must respectfully disagree with the position that Anthony Jackson got to make the calls about how this case was defended. We've cited in our brief United States Supreme Court authority to the effect that there are about 5 decisions that a defendant gets to make. One of them is whether or not to enter a plea. One of them is whether or not to testify. I think there are 3 others.
I thought there were only 3. Whether he wants to retain counsel or have appointed counsel, whether he wants to have a trial or plea, and whether he wants to testify or not.
There's actually 4, then there's right to appeal, but we're diverging away. You know,
I was
let's
going to
get
take a
back on
moment
task
to,
here.
I would have looked in my brief if the court thought it was important enough. Anthony Jackson went to trial with no defense, and succinctly stated the reason is There was no insanity defense
So the guy
presented.
gets into a cab with a gun, mace, and latex gloves. What's your defense?
Anthony Jackson explained why he carried a gun. Dangerous neighborhood.
And
was a
the
football
latex
game.
gloves?
And he was holding it for
Do the
someone
latex
else.
gloves help in a dangerous neighborhood?
I don't believe there was ever any discussion about that, either at trial or,
Did he have latex
in the
gloves
hearing.
with him? You don't remember
oh,
that?
no, sir, I'm not saying that. I don't believe there was any explanation
He
for
did
that.
give a-
Okay.
There was no defense in this case. There was no insanity defense, and as Judge Wooten found, presentation of that defense completely emasculated the better defense of self-defense.
Well, you know, there are a load of cases out there that say that there is nothing that there's nothing improper with presenting both insanity and self-defense.
I don't disagree with that. The case we've cited, I believe it's Merck, says there's nothing precluding that. They don't say it's necessarily a good idea. In that case, obviously, the defendant had been convicted, or he wouldn't have been appealing.
Well, that's
If
all
you-
of the cases.
That's true. Anthony Jackson went to trial with no defense in this case. Defense counsel did not understand the burden of proof. The so-called expert that was presented did not understand the legal definition of insanity in Florida. There was no insanity defense here. Anthony
Well, it's
Jackson...
not like there's a self-defense defense either.
That's not what Judge Wooten found, and I believe there was. Whether it would have been believed by the jury is a matter of opinion. Judge Wooten found it might be. There was a reasonable probability that it would be. You know, the defense's defense, other than the testimony of the expert, Anthony Jackson said what happened in his initial statement, and there are elements of self-defense there, that he was being choked, that other attempts to extricate himself from that situation did not work, the mace did not work, that the victim was threatening to effing kill him. That testimony was
You're in your
the...
rebuttal, just so you're aware. Go ahead.
I'll get into that a little bit. The testimony, both the original statement, the trial testimony, and the testimony at the hearing were all consistent with self-defense.
Which claim can you point to that Mr. Jackson timely filed that was enlarged upon and ultimately became Claim J, which Judge Wooten found to be the winning ticket, so to speak, for Mr. Jackson?
Well, I believe Judge Lambert suggested that maybe it was one of the ineffective assistance of counsel claims. Having to, well, let me point this out.
Wasn't the only thing in the original petition his complaint that there wasn't enough evidence of insanity put before the jury?
And that would make her ineffective if she presented a defense for which there was no evidence.
Right, but Claim J ultimately wasn't, there was too little. Claim J was these were totally conflicting defenses and it was a fail on many levels.
Because of the fact that no credible evidence of insanity was presented. As Judge Cohen has pointed out, the cases say you can present two defenses if they're interrelated in some way, if they support each other. In this case, I would say it was even worse than them canceling each other out. And I have about 19 seconds here.
Okay?
Does the court have any questions?
Not right now.
Thank you.
Thank you.
Thank you.
It sounds like counsel's arguing that a motion to amend automatically allows or assumes that there can be an extension of time to add new claims. I think if you look at the state filed supplemental authority, it's just representative of many cases that say that the court doesn't have jurisdiction to change what the rules are. And the rule clearly says it has to be, a new claim has to be filed within the 2-year period of time. Counsel clearly knew what the burden of proof was. That was state had to prove intent. Counsel also clearly knew that to prevail on self-defense, she had to show that the defendant's belief that he had to use deadly force was reasonable. So counsel took an expert that she had, that the state didn't try to knock out insanity defense. That might have been a different issue. It was presented.
What about her argument that the state never objected at the hearing?
Well, again, I would point to Salser, the supplemental authority that indicates it's a jurisdictional, that it's jurisdictional. The trial court doesn't have jurisdiction to expand the rules of procedure. The method it would be to use another means to try to get, if Steele v. Kehoe or some other means to get that issue before the court.
So when the court ordered the state to respond to the 3850 petition, the state could have objected to the timeliness of it at that time, correct?
Well, absolutely, the state could have. But
And when they convened to hold a hearing on it, or when the hearing was set, there was certainly notice the state could have objected at that time,
the state
correct?
could have, but that still doesn't give the trial court jurisdiction to consider and rule on untimely issues. The rule doesn't allow it. The courts have determined that it is jurisdictional. The court can't expand the what's allowed by the rule. So
By virtue of the state not objecting at all these points in the process where it could have, was the state conceding that was an enlargement of a timely filed claim?
no, I don't think it was the state's concession. I think whether it was overlooked or not, the fact remains the trial court didn't have jurisdiction to consider under the rules and under case law issues that were not timely raised. And it's clear that the state argued the merits of it, but the court still didn't have jurisdiction to rule on the particular issue that was an untimely issue. The state relies on its brief for the remainder of the cross appeal and asked the court to find that the trial court's ruling was incorrect and to reverse. Thank you.
Thank you.
Counsel, thank you. All right, Ms. Kaufman, I'll give you a minute 13. How about that? You want to, you don't have to if you want. You wait? Okay, thank you. All right, counsel, thank you.
All right. The Court of Appeal for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning. Welcome to another oral argument session of the 5th District Court of Appeal. As our marshal has indicated, I'm Judge Lambert, presiding over our 4 cases that we have today. If anybody's here, just so World Trade Towers and Space Coast, that was dismissed yesterday by the appellant, so if for some reason you're here on that case still, there's no oral argument in that case. That case has been dismissed. Let me introduce the panel that's going to be hearing cases today. To my right and to your left is Judge Jay Cohen. And to my left, your right, is Judge Robin Lemonidis. She is a circuit judge from Brevard County, sitting in this week for Judge Torpy. She's been helping us. We've been very appreciative of her efforts here. And so she is with us as the third member of our panel. As I indicated, we have 4 cases today. 1 criminal, 3 civil cases, 15 minutes on the criminal case and per side, and 20 minutes per side on the civil cases. If you happen to have a cell phone or other electronic device, please turn that off or put it in silent so you're not distracting the attorneys when they are giving their oral arguments. I will reserve 5 minutes on for rebuttal for each side unless you tell me something different. On the first case, because we have a cross appeal as well, If the appellee wants to reserve 5 minutes to also to address any issues in the cross appeal, let me know. If you don't, let me know as well. All right, that being said, I'll call the first case, 15-1524, State of Florida versus Anthony Marquise Jackson.
May it please the court, I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. This is an appeal by the state from a trial court's order granting post-conviction relief and ordering a new trial. This was the sole issue that was raised on direct appeal, and as Judge Cohen may remember, as he sat on that panel, and while it was the sole and exact same issue that was raised on direct appeal, the state acknowledges that it's not law of the case because this court's decision in that case was a PCA. However, the state makes the same argument today that it made 6 or so years ago, and that is that not only was trial counsel not ineffective for raising 2 absolute defenses, but was brilliant by taking 2 defenses and giving the jury 2 reasons to find that the defendant's horrendous actions that night were either excusable or justifiable.
May I ask, do you believe that the amended petition, that the amended petition filed by counsel after Mr. Jackson already filed his timely petition, do you see that as an enlargement of a claim that Mr. Jackson made initially?
Of the ineffective assistance claim?
Yes, and the ineffective assistance. The one where he discussed, I'm sorry, the exact letter is escaping me, but where he talks about mens rea. He lacked the requisite mens rea to...
I think it was an enlargement. The state addressed it on the merits as if it were a valid enlargement of a previously raised issue. And I don't contest that at this point. I think that it's clear that regardless of whether that portion, I think it was letter J.
So you concede that it relates back? Because I don't think you did on your brief.
But the state argued on the brief what did not relate back was the claim regarding the stand your ground and self-defense that was a new issue raised. The defendant in his...
Or how about the insanity?
Well, it's clear that in the defendant's original motion...
His handwritten motion.
Right. He argued that trial counsel was ineffective for not presenting even more insanity evidence, his Social Security documents and stuff.
So you think a claim that it was ineffective assistance to raise insanity relates back to that? Is that what you...
No, absolutely not.
Counsel, that sounds like that's exactly what you just said.
Well, no, and I don't agree with that. I don't think that...
You don't agree with what you said, or you didn't say it?
I'm sorry. I thought this was referring to the state's argument